Welcome to our next class. Today we'll be covering Chapter 8, Negligence and Strict Liability. Previously we got a little bit into negligence where we talked about intentional torts. Negligence is also it's a cause of action related to a tort as well. So the main difference between an intentional tort and negligence is intent, right? With an intentional tort, you intend the action that causes damage. With negligence, you then intend it. In essence, it's an accident. I guess that's probably the best way to describe negligence. And also, we'll talk about strict liability. There aren't too many things in the law that are strict liability, and I want to touch a little bit on that whole concept of strict liability. What's interesting about strict liability is, in essence, if you are found to be strictly liable, it means that you don't have any defenses, which is very, very extreme, very draconian, very unusual in the law. You always have a defense. But when we're talking about strict liability, you don't. So let's talk a little bit about some of the topics then that we're going to actually talk about. So negligence. We'll talk a little bit about the breach of the duty of care. That's what gives rise to a claim for negligence. We'll also talk about a factual cause and scope of liability. We'll talk about harm or injury. And then we'll talk about some of the defenses to negligence. And then we'll finish up the chapter by talking about strict liability. And those are activities that give rise to strict liability because your defenses, I guess I shouldn't say you don't have any defenses, but they're extremely limited. Because they are extremely limited, there are only certain activities that will rise to this level of strict liability. In other words, it's what the law calls inherently dangerous activities. And then we'll talk about some defenses to strict liability. As I mentioned, they're very, very few and difficult to really use in general. And that's why I usually refer to strict liability as not, the person or entity not having any defenses. So that's not entirely accurate, but we'll talk about it as we get there. So let's start off with a definition of negligence. So if we're going to talk about negligence, we certainly need to understand what negligence is. It's conduct that falls below the standard established by law for the protection of others against unreasonable risk of harm. So in other words, as a society, we impose certain duties on people. So again, I'm going to go back. I know I've used this in the past, but I'm going to go back to my example of the car. If you drive a car, then the law imposes on you a duty that you're going to drive that car in a careful and reasonable manner, meaning like any other reasonable person in your situation would do. If your conduct falls below that standard or below that duty that's been established by law, then you're going to be liable if you hurt someone. And that's another key factor. You have to actually hurt somebody. You may fall below the standard or duty, but if you don't cause injury or harm, then you're not liable for negligence, even though you may have been negligent. So that's an important distinction or concept as well. So again, using my car example, right? I'm supposed to drive. I have a duty. As soon as I get into that car, I have a duty to drive at the speed limit, or even more broadly, I have a duty to follow all traffic laws. If I do not follow any traffic law, again, right? Let me go back to my speeding example. So let's say that I'm speeding. Let's say that the speed limit is 45 miles an hour and I'm traveling 60 miles an hour. Well, I've breached that duty. Is that negligence? Technically, yes. Under the definition, it is negligence. But I'm missing a crucial element in order to be found liable for negligence or of negligence, and that is I haven't harmed somebody. So even though I may be speeding, as long as I don't harm somebody, I'm okay. Now, that isn't to say that you can't be stopped by the police. That's a whole separate story, right? Now we're not talking about negligence. Now we're talking a violation of a criminal law. Traffic laws are criminal laws. So you may be found guilty or liable of that, but you certainly can't be found liable for negligence unless you injure or hurt somebody. So that's also an important distinction or concept to remember. So let's talk about some of the elements of negligence. The law, any cause of action that a person brings, whether it's for negligence, trespass, an intentional tort, right, like assault, battery, even breach of contract that we haven't talked about yet, but any violation of a legal duty or a legal standard has elements. And in order to prevail in your lawsuit, if you're the plaintiff, you have to satisfy or meet each of the elements. So negligence is really no different. In an action or an action for negligence consists of 5 elements, each of which the plaintiff must prove. If you prove 4 out of the 5, not enough. Not enough. You need to prove all 5 elements. So the first element, duty of care. And that's what I was talking about, again, in my car example, right? The duty of care usually is probably one of the simplest elements to prove by the plaintiff. If you're the defendant, you either had a duty of care or you didn't. Usually duties of care are imposed either by law or by the situation or by the relationship between the parties. Again, I'm going to stick to my simple car example. As soon as I get into my vehicle, I assume a duty of care. And that being that I'm going to drive my car in a careful manner so as not to injure anybody else. So that's the duty. And that duty is automatic. I don't have to do anything. As soon as I step into that car and I drive that car onto the street, I've assumed that duty. So if I get into a car accident, and let's say it was my fault, usually it's very, very simple for the plaintiff to prove that there was a duty because I was inside my car. That's all really that it takes, right? As soon as I start driving, I incur that duty. Second, or the second element, breach of that duty. Well, that one is an element that sometimes gets attacked by the defense if you're the plaintiff. I may have a duty, but did I breach that duty? So really that's a factual situation whether the duty was breached or not. In my example, if I caused an accident, then many questions are going to be asked, right? Was I driving over the speed limit? If I was, then I breached the duty of care. Did I run over a stop sign? If I did, then I breached the duty of care. So those are very simple examples. Sometimes it's not that simple. Depending on the type of situation, it may not be that easy to determine whether you breach that duty or not. And we'll talk a little bit about that when we discuss some of the defenses. The next element is what we call factual cause. So in other words, you have to be the cause of the other person's injuries. So for example, in my automobile accident example, if I was speeding and I crashed into you and you suffered hospital bills, right? You had to go to the hospital and you spent a week at the hospital. Well, I am the factual cause, and here the slide says factual case. It should be actually factual cause. I am the factual cause of your of your injuries. I caused them, as opposed to someone else causing them. So, for example, let's say that using the same example with the car, let's say that I'm speeding and I'm about to hit you, but you're able to move out of the way, right? You changed lanes, and someone else hits you because they ran a stop sign. So in real life, that's usually how accidents happen, right? There's simultaneous things going, or simultaneous events that are occurring at the same time. So that's an example of, did I have a duty of care? Yes, I did. Did I breach that duty? Yeah, I did. I was speeding, so I breached the duty. But was I the factual cause of your injuries, your accident? No, I didn't hit you. You actually moved out of the way, and somebody else that ran a stop sign hit you. So I was not the cause of the accident, the factual cause. So that's what we mean by that. So it has to be, and again, there are some situations where it's not so simple to determine whether one person was the factual cause or another person. So I'll give some examples of that later on as well. The fourth element is harm. So there has to be actual harm. In my accident example, it's very simple. Obviously, if I hit you, you suffered harm. Even if you don't go to the hospital, right? Your car was damaged. So that's still harm. I'm going to have to pay for the damage to your car. So even though you may not have been physically injured, your personal property, your car, was. So that's harm. So harm can either be to the person or to someone else's property. And scope of liability. So again, it's interrelated with the factual cause. It has to be within the scope of liability. So we're going to talk about each of these in a little more detail. Breach of duty of care. There is something in the law called the reasonable person standard, and that's, the law likes to use this fictitious or mythical reasonable person in a lot of different situations. And negligence is one of the situations where we use a reasonable person standard. And what that means is, again, remember, we're talking about the breach of the duty of care. So under the reasonable person standard, the law says that the degree of care that a reasonable person would exercise under all the circumstances. So that is the type of duty that is imposed upon you. So when we're looking to make a determination, and by we, I mean the courts, when the courts are looking to make a determination whether you breach the duty of care, they're going to look at from this reasonable person standard, right? So a reasonable person in your same situation, what precautions would they have exercised? So in other words, we're not going to hold you to a higher standard. We're going to hold you to the same standard as a reasonable person would be expected to conduct themselves in that particular situation, right? Now, there are a couple of exceptions to this. One is children, and the other one is physical disability. So children must conform to conduct of a reasonable person of the same age, intelligence, and experience under all the circumstances. So in other words, we're not going to hold a 5-year-old child to the same standard as a 15-year-old child. Big difference there in age. I don't want to really say intelligence because it's kind of hard to, a 5-year-old may be just as intelligent as the 15-year-old, but they don't have the experience. So when we talk about intelligence, I'm not gonna isolate it. I'm gonna lump it together with experience. So intelligence and experience under the circumstances. So for kids, those are the factors that we're gonna look at. For adults, we don't look at the age and we don't look at the intelligence and experience. We're gonna hold all adults to a similar standard. And under physical disability, a disabled person's conduct must conform to that of a reasonable person under the same disability, right? So if a person uses a wheelchair, then we're going to hold that person's conduct to we're going to compare it, right? That's probably the best word. We're going to compare that person's conduct to a similarly situated person. So if that person, again, is in a wheelchair, we're going to say, okay, what would a person in a wheelchair have done under that same set of circumstances? So that's what we mean by that. So that really is what we call the standard of care. And that becomes very, very important in negligence actions because it goes to show whether that standard was breached or not. Couple of things here. Again, one more exception: mental disability. A mentally disabled person is held to the reasonable person standard. In other words, what would a similarly situated person have done in that same situation? So in other words, if the person, again, is mentally challenged, what would another mentally challenged person have done under those set of circumstances? So as you could see, it's supposed to be an objective standard, but it really becomes subjective only because how do we know, right, what a mentally disabled person are unless we are mentally disabled? It's very difficult to put yourself in that situation. Here's another exception, but this one goes the other way, right? We've seen some exceptions where we're going to hold people to a lower standard, right? Especially in the case of kids or people that are mentally disabled. But if you have superior skill or knowledge, you're going to be held to a higher standard. So if a person has skills or knowledge beyond those possessed by most others, these skills or knowledge are circumstances to be taken into account in determining whether the person has acted with reasonable care. So I think I gave an example in class of the Good Samaritan laws. So again, right, if you're walking down the street and somebody gets run over in front of you, under Florida law, you do not have a duty to assist that person. As I mentioned in class, as harsh as it may sound, you have the right to watch that person die and not do anything. You're not breaching any duty at that point. But if you're a doctor, it's a different story. Now you have superior skill or knowledge. So now you can assist that person. You can save that person. You have the skill set. So you're going to be held to a higher standard. Likewise, if you're a professional, you're going to be held to a higher standard than if you're not a professional. A good example of that, let's see, I'm a lawyer, right? So if I enter into a contract with you, and you're not a lawyer, I'm usually going to be held to a higher standard because I have superior skill or knowledge. I'm trained as a lawyer. I'm trained to draft and read and interpret these documents and supposedly I know the law that applies to them as well, which you as a non-lawyer would not know. So I'm going to be held to a higher standard. So that's what we mean by superior skill or knowledge. Usually most professionals or most people with training are going to be held to a higher standard, but it depends on the situation as well. And what is that standard? It's still going to be a reasonable person standard, but they're going to be compared to a like individual. So what would another doctor have done in that situation? What would another lawyer have done in that situation? What about emergencies? Well, the reasonable person standard applies, but an unexpected emergency is considered part of the circumstances. And so there's other laws in there that come into play. I talked a little bit about the Good Samaritan law, right? Where even though you don't have a duty to help somebody out, if you do, and let's say the person suffers additional injuries because of what you did, then that person cannot sue you. So that would be an example of what happens during an emergency. So we're going to take into consideration, if there's an emergency, the reasonable standard is still going to apply, but we're also going to take into consideration the unexpected emergency. What happened, and did you act, not act, and so forth. Violation of a statute. If this statute applies, the violation is negligence per se in most states. So for example, if there's a statute that sets a duty or standard of care, the fact that you violate that statute means that it's an automatic breach. So in other words, I don't need to bring in a reasonable person standard and go through that whole analysis and say, what would a reasonable person have done? Just the fact that you violated the statute means that you're liable. An example of that in Florida would be the Florida Building Code. Contractors, architects, engineers are supposed to build structures that comply with the Florida Building Code. The Florida Building Code is although the building code is not in the statute itself, there is a statute that adopts the Florida Building Code. So a violation of the Florida Building Code is a violation of a statute. So for example, if let's say that you're a roofer and the Florida Building Code says that you have to build a roof to a certain standard, and let's say that you don't, you fall below that standard. At that point, I could sue you for violation of the Florida Building Code, and that would be negligence per se. So in other words, we're going to assume that the fact that you violated the building code is negligence. So I don't have to show some of the other elements. I still have to show that you suffered damages. That's pretty much about it. I don't have to show the whole duty and breach of duty because that's implied. It's already in the code. That's what the code means. It creates that duty, and the breach of the statute is a breach of that duty. So that's what we mean when we say negligence per se. So let's talk about negligence and negligence per se. There's a very good chart in the book that actually walks you step by step, and it's very helpful in trying to make this determination. So you're always going to look at from the defendant's perspective, right? Because if you're the plaintiff, you're the one that was injured. So we're going to ask the questions from the plaintiff's perspective. So the first question is, does the defendant's conduct violate any statute? If the answer is no, then we go over to the left-hand side, the right-hand side, which says, was the conduct reasonable under the circumstances? And that's where that whole reasonable person standard is going to come in, right? So we're going to ask, what would a reasonable person under those same set of circumstances have done. So if the conduct was reasonable, then the defendant is not liable for negligence. If the conduct was not reasonable, then defendant is liable if there is causation and protected harm are proven. So in other words, you still have to prove that the defendant was the cause of your harm or your injuries, and that you suffered some type of injury, right? Whether it be to yourself or your property. So let's go back up to the first one, right? Because we remember we traveled under the no. So let's say that the defendant's conduct violates a statute, so that the answer is yes. Then we move down to the next one, next question that needs to be asked. Does the statute expressly provide for civil liberty? If the answer is yes, then you go back down to the bottom and figure out if the person was the cause of the harm and if there was actual harm. If the answer to that question is no, then the next question that needs to be answered is the statute intended to protect a class of persons, which includes the plaintiff, from that type of hazard and harm? So a good example here again would be my building code violation, right? So the building code is intended to protect all Florida homeowners or purchasers of homes. So in that particular example, that plaintiff would be within the class of persons from that type of harm and hazard, right? So if your roof was built improperly, that's exactly what the building code was intended to protect you from. The building code is so that the roof is properly built, so you don't have any problems with water intrusion or with hurricanes. And so that was what was intended. And so the answer to that one would be yes. So you, again, would find yourself at that last box there. So let's talk a little bit about the duty to act. And again, I spoke a little bit about this in class with my Good Samaritan example. A person is under a duty to all others at all times to exercise reasonable care for the safety of the other persons and property. However, except in special circumstances, no one is required to aid another in peril. So in other words, our duty is to act in a reasonable manner so that we don't hurt other people. But if somebody else is hurt, not because of our fault or not because of something that we did, then there is no duty to assist that person. And again, that's the examples that I've been given both in class and in my lectures about the person that gets hurt, right? So you don't have a duty to help somebody that is injured. So let's talk a little bit about the duties of possessors of land. And what do we mean by that? Well, possessors of land could be an owner, right? Could be a homeowner. It could be a business owner. Possessor of land could also be a renter. Those are all possessors of land. So in other words, anybody that has the legal right to be on that land, right, on a permanent basis, whether it's via a deed, right, because it's your property, or a lease, so that you're legally renting the property, you are the possessor of that property. And there are certain duties that the law implies, or the law, I guess implies is not the right word, but the law requires of possessors of land. So there are different duties that are owed to different people depending on their status upon the land. So let's talk about trespassers. So the only duty, and again, let's go back to your home, right? Let's say that you're a homeowner. And so the question is, what is your duty to trespassers? Well, the only duty that you have is not to injure intentionally. So in other words, I can't set up booby traps in my backyard, right? If I know that you are, let's say that you're my next door neighbor, and I know that every Saturday you jump over the wall and look around my backyard. Well, I can't put anything on my property to intentionally injure you, right? So I can't put, I'm trying to think of a good example. I can't put a gun tied to a spring, right? What we call these spring guns. So that once you cross into my property, the gun goes off and shoots you. Well, I can't do that. Or I can't create a hole in the ground and cover it up with dirt so that you fall in there because I know you're going to be walking around. So that I can't do. But let's assume that you do have holes on your property and that you've had those holes there for a long time. And a trespasser jumps over the fence, right? Your neighbor again jumps over the fence and actually trips and falls into the hole and breaks his leg. At that point, your neighbor cannot sue you for negligence. And the reason is that you don't have a duty to trespassers. Your neighbor was a trespasser, and even though you have a duty not to injure, that duty is only intentional injuring, right? So you had those holes on your property. You didn't dig those holes to injure your neighbor. Maybe you're digging a pool and your neighbor fell into the hole where you're going to have your pool. So again, that's an example. What about the duty to licensees? And let's back up a little bit. What is a licensee? A licensee is a person that you give a license or a permission to come onto your property. So most shoppers in your business would be licensees. Now, licenses can be revoked. So even though I may give you permission to come onto my property, I can revoke that permission, right? I could say, you have to leave. You're no longer welcome. I'm sorry. And that's also true of a business. People that, shoppers are business invitees, so they're licensees. And your duty as a landowner to licensees is to warn of known dangerous conditions licensees are unlikely to discover for themselves. So again, you know your property better than anybody else. If you know that there's a problem, for example, again, let's say you're building that pool and there's a hole and it's not easy to see. So if you invite somebody over to your house, or you give somebody a license, right, to come onto your property, you have to warn them of those dangerous conditions. You have to say, hey, if you go in the backyard, be careful because I'm building a pool and there's a hole. That really is the extent of the warning you have to provide. Now, if the hole is visible, right, if it's readily visible and anybody that goes into that backyard can see that hole, then you don't even have to tell them about it, right? Because again, they're only conditions that they're unlikely to discover for themselves. Another example, let's say that you have a 2-story house. And let's say that you know that the 5th step is not properly attached. And you know that, so you always skip that step. Well, somebody that you invite over is not going to know that. So you have a duty to warn them that there's an issue with that step, because that is not something that they could discover for themselves. I guess I shouldn't say that. I mean, they would discover it for themselves, but by that point it'd be too late, right? They usually get hurt. So that's an example of the duty that you would have to a licensee. And I guess I'm sort of mixing licensees with invitees. So licensees, so to correct that, licensees is somebody that you grant a license or the right to use your property. A good example of that would be like Airbnb, right? And even that is, there's a distinction there. I mean, you could be both a licensee and an invitee. So, but you grant somebody a license to use your property. So they come on board, right, based on that license. So it's very similar in a lot of respects to an invitee. An invitee is somebody that you invite, whether it's from a business perspective or a personal perspective. And there you're going to be held to a higher standard, right? So the lowest standard is to trespassers. The next in the hierarchy, the next highest would be a duty to a licensee, and then the highest duty is that's owed to invitees. And for obvious reasons, right? You invited them. So that's the highest duty. And when I say invitees or you invited them, remember, it could be your house or it could be a business. So your duty to invitees is to exercise reasonable care to protect against dangerous conditions that you should know of, but invitees are likely to discover. Notice the subtle difference between the standard here between a licensee or a duty to licensee as opposed to a duty to an invitee. There's really only one word that's different. If you look, let's go back here. The duty to licensees is to warn of known dangerous conditions. To warn of known, right? So those that you know about, you have to warn. If it's an invitee, it's to warn or to protect against dangerous conditions that the possessor should know of. So now it's not only those that you know about, but those that you should know about. And what do we mean by that? This imposes an additional duty on you. And so if you should know, that means that now you have a duty to inspect and make sure that everything is okay. So in my stair example, right? Let's say that you didn't know about it. There was a step that was wrong. But you should know about it, because if you're inviting people over to your house, you should know of any potential hazards. So now you have a duty to inspect. Let's look at it from a business perspective, because that's usually where we find most of these lawsuits. This is the example of Publix, where, let's say there's a customer and they spill oil in aisle 5. And so the person doesn't tell anybody, and another customer comes and doesn't see it and slips in the oil and falls and breaks their leg or breaks their neck, and they sue Publix. Well, those shoppers were invitees. Publix didn't know of the oil, right? Because nobody told them, but they should have known. So what happens at a place like Publix, constantly there has to be either the manager or an employee that's responsible for the different aisles, and every so often, whether it's 15 minutes, 30 minutes, an hour, should walk those aisles and see if there's anything wrong, right? Did somebody spill something, or is there another type of dangerous condition that needs to be looked at. So that's what I mean by inspecting, right? There's an additional duty now to find those items or those things that are wrong. Here's a good graph, in essence, that shows kind of the hierarchy of the duties. So we start off with a yellow box in the middle, duty to trespassers, it's not to injure intentionally. Then greater, right? We expand the duty to a licensee, which is to warn of known dangers. And then we expand that even further to invitees, which is to exercise reasonable care to protect against dangerous conditions about which the possessor should know. So now we are adding this additional duty on the possessor of land to inspect and make sure that there is nothing that could harm the invitees. All right, so let's move on to the next one. I'm not going to spend a lot of time on this. It's actually a pretty complicated concept. It's called res ipsa loquitur. It permits the jury to infer both negligent conduct and causation. I'll let you read this, read a little bit more about this in the book, but again, I would not spend too much time on this. It's a fairly difficult concept, even for a lot of law students to understand. This is traditionally used in those situations where a person has been harmed or hurt, and because of the situation, it's very difficult to determine who had a duty, or better yet, I mean, I guess the duty is established, but who breached that duty and who caused the harms, right? So for example, let's say that you're walking a construction zone, right? And I'm sure a lot of you have been through construction areas where they create these protections for pedestrians that as they're walking next to a high rise where they're making improvements, they put all this protection on the sidewalk so that pedestrians can walk. And let's assume that there are several subcontractors working on the job at once. It could be 5, 6, 10 different subcontractors. And let's say that you're walking down, through this protection, and suddenly you get hit in the head with a hammer. And you have to go to the hospital, you suffer injuries. Well, you don't know whose hammer that was, right? You don't know who it belonged to. It could have been, one of any, right? One of hundreds of people that were working on that job site, working for different employers. So at that point, who do you sue? And how do you prove who was the one that actually breached their duty? Who was the one that actually caused the harm? Well, res ipsa loquitur allows you, it's a legal cause of action that actually allows you to make a claim in those types of situations where it's very difficult to prove who caused the harm, that you in fact were harmed, but it's very difficult to prove who caused the harm. So that's about all I'm going to say about this. So factual cause, again, that's another element. The defendant's conduct has to be the factual cause of the harm when the harm would not have occurred absent the conduct. So in other words, that's what we call in law the but-for test. But for the defendant's negligence, you would not have been hurt. So again, I already spoke a little bit about factual cause before. I don't want to expand too much on it. It's not a difficult concept, but it is an important concept in that the defendant's conduct has to be the one that causes the harm or the injury. An example of where this gets complicated and where this gets litigated in the courts. Let's say that I'm driving my car down the road, I'm speeding, I hit you. You get hurt, an ambulance picks you up, is taking you to the hospital, As the ambulance is taking you to the hospital, a car driven by Jane Doe hits the ambulance and causes you further damage. So really at that point, it's very difficult to determine who caused which damage. Was I the factual cause of your damage? Well, I mean, at least to a certain extent, yes, right? Because you were going to the hospital. But this other person that hit the ambulance aggravated your injuries. So I can't really be responsible for that aggravation, right? To the extent that we're able to separate that. That's almost, that's like a complicated example of factual cause, but I have to be the actual factual cause of your harm. Legally, we also sometimes call that an exterior or a superseding cause. So even though I may have caused you harm or injury, there could be another person or another situation that supersedes and actually creates greater or additional harm than I did. Scope of liability is what we call proximate cause, and that's why earlier I had said it was related to cause. Liability is limited to those harms that result from the risk that made the defendant's conduct tortious. Which again, it goes back to the same thing that I was talking about. My liability is going to be limited to the harm that I cause, right? In that example with the ambulance. So, maybe you had a really bad broken leg that required surgery and you were on your way to the hospital, and when the ambulance was hit by Jane Doe, now you suffered, serious internal injuries, and you had to spend 6 months in the hospital and rehab and all of that. I can't be responsible for those injuries. I wasn't the proximate cause. I may have been the cause indirectly, but I wasn't the proximate cause. Jane Doe was. So that's what we mean by limiting the liability to those that were actually proximately caused. And sometimes it's not that simple. So again, when we're talking about proximate cause, one of the things that courts will look at is, was it foreseeable? So in other words, we're going to exclude liability for harms that were sufficiently unforeseeable at the time of the defendant's tortious conduct, that they were not among the risks that made the defendant negligent. So again, going back to my ambulance example, it wasn't foreseeable that the ambulance would also get into an accident and that your injuries would be made worse than they were, right? So that would be an example of foreseeability. It's not foreseeable that that would happen. Likewise, let me give you another example of proximate cause. Again, going back to my accident example, let's say we got into a car accident. You have a really bad broken bone that requires surgery. You go to the hospital, you make it to the hospital, and the doctor that is operating on you operates on the wrong leg. So now you've suffered additional damage. Now, I'm not the proximate cause of that injury because it would not have been foreseeable that the doctor would have operated on the wrong leg. So I cannot be held liable for those injuries because I'm not the proximate cause of those injuries. Those examples that I gave also would be what we call, again, superseding causes. So it's an intervening act that relieves the defendant of liability. So again, this is all under proximate cause. So the example in the ambulance and the example of the doctor there, those are all superseding causes. Those are intervening acts that usually would relieve me of liability. It's very difficult to prove how much of your injuries were actually caused by me, as those that were, especially in an accident, as those that were actually caused by the second accident. So we would say that that's a superseding cause, and your claim would be against Jane Doe in my example. So when we talk about harm, which is another element, it has to be harm to a legally protected interest. Courts determine which interests are protected from negligent interference. So for example, bodily injury would always be a harm. Injury to personal property, that would always be a harm. Those are the types of things that we're talking about. And the burden of proof, the plaintiff must prove that defendant's negligent conduct caused the harm to that legally protected interest. So the plaintiff always has the burden of proof. Probably one of the main defenses to negligence is called contributory negligence, sometimes also called comparative negligence. And that's the failure of a plaintiff to exercise reasonable care for his own protection, which in a few states prevents the plaintiff from recovering anything. Some states, it's a very harsh law, but some states is even if you were 1% negligence yourself, you're not allowed to recover because you participated in that injury, right? So for example, let's say that you are a pedestrian and you're crossing the street, and I hit you as I'm driving down the road. And I hit you because I was texting, so I didn't see you. So was I negligent? Sure, I was definitely negligent. Should not have been testing. But let's say that you, as the pedestrian, you were jaywalking. So you were not crossing the road at a crosswalk. So you are also negligent. So in certain states, you wouldn't be able to sue. In Florida, we have comparative negligence, which, just like the word says, it's a comparison of negligence. So what we would do in Florida, we would assign a percentage of fault to each of the individuals. Percent of fault to the plaintiff for texting, and a percent of fault to the pedestrian for jaywalking. So let's assume that the pedestrian suffers $1 million in damages and that they're found to be 50% at fault. In Florida, what that means is that the plaintiff only has to pay half of the damages. So in my example, the plaintiff would only have to pay for $500,000. So that's the way comparative negligence works in Florida, and that's actually a defense as well to negligence. Well, there it is. There's comparative negligence. Damages are divided between the parties in proportion to their degree of negligence. Applies in almost all states. So in Florida, we used to have many years ago, we used to have contributory negligence, but that's too draconian, right? Because even if you're 1% at fault, you can't recover anything. So that's really not fair either. So actually, comparative negligence is the fairest way, really, to allocate damages when both the plaintiff and the defendant are at fault. And in most situations, with few exceptions, usually there is some degree of liability or fault on both sides. Depends on the situation, but that's usually the case. So let's talk about some of the, continue to talk about some of the defenses to negligence. The other one is assumption of risk. So the plaintiffs expressed consent to encounter a known danger. Some states still apply implied assumption of the risk. But what this means is, for example, if you know that an activity is dangerous and you decide to do it anyway, then you assume that risk. A lot of times, if an activity is very dangerous, usually most companies will make you sign a waiver, especially indicating very specifically that you're assuming the risk of that danger. So an example of this would be skydiving, for example, right? So you know that skydiving is dangerous, but you enjoy it, you want to do it anyway. And so usually what happens is you're going to have to sign a waiver that you're assuming the risk of anything that can happen. So assumption of risk is a defense. It doesn't apply in all situations. Even in my skydiving example, it may or may not be true. So let's say that you do go skydiving. Let's say that the agency packs your parachute and your parachute doesn't open and you die. So is the agency liable, right? Your estate sues the agency, and as a defense they say, hey, assumption of risk. This person knew the risk, they assumed it, they signed a waiver, and so we're not liable. And that may or may not be true. If the parachute was properly packed and there was absolutely nothing wrong with the equipment, and it was just an accident, it didn't open for whatever reason, then yes, the assumption of risk defense would apply and they would not be liable. However, if they improperly packed your parachute, or if there was some other equipment failure that was under their control, then assumption of risk would not apply, even if you had signed a waiver. They would still be liable. So assumption of the risk, tricky defense. It may or may not apply depending on the situation. So again, defenses to negligent action. So here we have a whole chart of questions that you can ask. Again, right, you have assumption of risk, you have contributory negligence, you have comparative negligence, and what we call the last clear chance. I'll let you go through that. I'm not going to spend a lot of time on the slide. Let you read about some of those in the book. They're just not as important. And we've already spoken about a lot of these anyway. Let's move on to strict liability. Strict liability is the liability for non-intentional, key factor there, it has to be non-intentional, and non-negligent conduct. So in other words, you didn't intend the harm, and in fact, you took every precaution. You were not negligent. You took every precaution, but you're still liable. That's what makes strict liability so harsh, and why we limit it to certain situations and certain activities. So what are those activities that give rise to strict liability? Well, it has to be what the law calls an abnormally dangerous activity. Strict liability is imposed for any activity that creates a foreseeable and highly significant risk of harm, and it's not one of common usage, right? So what do we mean by that? Well, keeping of animals. Strict liability is imposed for wild animals and usually for trespassing domestic animals. So for example, if you keep a tiger in your backyard and your tiger gets away, even though you had a 10-foot, 20-foot high fence, and you have no idea how the tiger got away, but you took every precaution, doesn't matter. Just because you have a wild animal, you're going to be strictly liable for any damage that animal causes. This is also going to be true of, I think I read recently about somebody that had a cobra that got away. Same thing, right? It doesn't matter that you took every precaution. If that cobra hurt somebody, you're going to be liable, even though you were not negligent and even though you took every precaution you could. So that's one of those situations where strict liability would be applied. Now, as far as defenses to strict liability, and I'll give you a couple of other examples of strict liability. Transporting hazardous materials, that's also strict liability. So if you're a business that transports nuclear waste, It doesn't matter that you took every precaution. If there's an issue, you're going to be strictly liable. So that's another example. Blasting is another example of an inherently dangerous activity that'll subject you to strict liability. If you cause damage because of your construction blasting, then you're going to be liable. So the defenses are very similar to the ones that we saw for negligence. Contributory negligence is not a defense to strict liability, right? So that's a key factor there. So even though the defendant may have been negligent, it's not a defense to strict liability. What about comparative negligence? Some states apply this doctrine to some strict liability cases. In Florida, we do not. So in Florida, if you have a tiger in your backyard, too bad. What do we mean by contributory negligence? Well, let's say that you have your tiger with your 20-foot fence and your your next door neighbor opens the fence so that the tiger gets out. Again, you didn't do anything wrong. Your neighbor did. Doesn't matter. You're going to be strictly liable. Even if the tiger eats your neighbor, right? You're still going to be liable. Even though it was your neighbor that opened the door and caused that issue, doesn't matter, because contributory negligence is not a defense. So you can't use that as a defense. Assumption of risk. Express assumption of risk is a defense to an action based upon strict liability. Some states apply implied assumption of risk to strict liability cases. So again, the defense there in the example that I just gave, your defense is not going to be contributory negligence or comparative negligence. Your defense is going to be assumption of risk, right? Your neighbor knew that you had a tiger in your backyard, opened the gate and went inside the backyard. So that would be assumption of risk. It may or may not work. I don't know. It depends on the courts on that one. But at least you can use that as a defense. Trying to think what other situation assumption of risk would apply to some of the other examples. I think mainly with the wild animals would probably be where we would see this assumption of risk used as a defense more often than not. Okay, this is the last slide for Chapter 8, negligence. And again, remember, this is just a very, very brief overview of negligence. Negligence is actually very, very complicated area of the law, very important area of the law. Whenever you see these commercials on TV about personal injury or wrongful death or nursing home abuse, right? Morgan & Morgan in the area has a lot of these types of commercials. That's what they're talking about. They're talking about negligence. So if they sue, they're suing under a negligence theory, and they have to prove all those, they got to prove all those elements that we just talked about. If you have any questions, please make sure to email me or save them for class. Other than that, that's all for this chapter.